Good day. My name is Martin Schweiger, and I will today walk you through Lesson 2 of our IP Bootcamp. This is an introductory course on new products and startup companies. Today we talk about what is IP. This lesson is for nerds and for non-nerds. The main question today is, what is IP? In practice, you can meet a lot of definitions of IP. The term intellectual property is used in different ways. Some are narrow and some are very broad. Let's start with a very general term for any intangible asset. It is something proprietary that doesn't exist as a physical object that can fall on your foot, but still it has value. That's a very broad definition of intellectual property. Most people think about IP as a sword. And I have put here an antique dagger so that you can better understand what I mean. They think that IP is something that you can use in order to defend yourself by attacking others. And that is true. IP can be a sword. An IP right allows you to forbid something that only you can do. It is something like a monopoly. But that is not the point. For startups, another aspect is much more important. When it comes to problems with IP, in most cases, it is that a startup stumbles over an intellectual property of one of their competitors. That usually ends the startup. Therefore, my personal opinion is that nothing beats freedom to operate. We are now at the next question. What is freedom to operate? I have put a picture of a very famous group game here. It is called Minefield. What you see here is a person that walks through a simulation of a minefield. The mines are little balls made of duct tape on the floor. The person is blindfolded, so he cannot see where he steps. There is a team member here who directs the player by giving commands so that he can walk through the minefield without stepping on one of the duct tape balls. If he steps on one of the duct tape balls, he has to leave the game. I like this analogy very much because it applies also to IP. Each one of the duct tape balls in this game can represent one intellectual property right. Some of them are dangerous, and I marked them here with a red IP, and some of them are not. You need an expert to discern what IP is dangerous and which one is not. In very short words, you may not be allowed to do what you want because your competition has acquired IP. A freedom to operate study highlights to you what you can do and what you cannot do. In the first place, in order to prepare a freedom to operate study, you need to know what IP is out there. So let's look at the various types of IP. In the narrowest sense, IP means registered and unregistered proprietary rights which exist over intangible assets. Let's first talk about registered IP. In the first place, we have patents and utility models. These are protective rights for technical inventions. Then we have trademarks. Trademarks are signs which are used to distinguish the origin of goods or services from one company from those of another company. Then we have registered designs. Registered designs are similar to copyrights, but they are registered with an intellectual property office. Then we have plant variety protection, which protects breeds of plants like flowers or vegetables, or also trees. Then we have registered semiconductor topographies and layout designs. They are rarely used in practice, and only those who need them know what it is. Then we have geographic indications. Geographic indications are used for products in order to denominate their origin from a specific part of a country. Very famous geographic indications are champagne or camembert, the French cheese. Then we have registered typographic fonts. A font is a collection of letters that is used on a computer or in a printed form, and there are various fonts, as you may know if you use the word processor program Microsoft Word. Examples for typographic fonts are Courier New or Arial. And then we have internet domains. Everybody knows what an internet domain is. It is used to denominate the address of a web page, and it is also used for emails. In addition to registered IP, we have also unregistered IP. Unregistered IP are core IP rights which do not require registration. We have trade names, company names, common law name rights, and rights under passing off in the first place. Then there are unregistered designs, which is very similar to copyright. Please note, a registration of a copyright is not required for copyright protection itself, but in some countries you need to register copyright for asserting copyrights against infringers. This is usually done before initiating a lawsuit against an infringer. Then there is unregistered IP in the form of confidential information, in trade secrets and know-how. You may ask now, why do you make a distinction between registered IP and non-registered IP? It's very simple. The narrow forms of IP are split into registrable and non-registrable due to the distinction that registrable IP is searchable, where it is never possible to conduct a comprehensive search in relation to non-registrable IP. That's important for our freedom to operate studies. How do you want to conduct a freedom to operate study over something that is non-searchable? This is literally impossible, which implies that each freedom to operate study also comes with a certain uncertainty. IP does not stop here. In a slightly broader sense, IP also encompasses those agreements granting permission for the sales of a product or provision of a service within a given territory, or even a context where the product or service is affected by an IP right. That's a very broad definition of IP. And we have IP especially in the form of IP assignment agreements, confidentiality agreements or NDAs, which is non-disclosure agreements. Then we have license agreements, and further we have research and development agreements, franchise agreements, joint venture agreements, distributorship agreements and supply agreements, and non-compete and non-solicitation agreements. As you can see here, the term IP can be very broad. In an even broader sense, IP also includes other key legal and business matters. Those matters affect IP rights, it is about products that encompass those rights, and it is about how IP is managed in a more general way. A few key examples are competition law issues and unfair business practices issues. A competition law issue arises when two companies engage with each other in order to secure a higher price level or to exclude the competition. Unfair business practices issues incur when companies try to use unfair business practices in order to improve their sales. Then we have product certification and registration issues, as well as regulatory approvals. This becomes an issue when pharmaceuticals, cosmetics, or medical products are introduced into a new market. These products need a product certification and a registration for security purposes. In many countries, waste handling is restricted, and so is mining and our other areas. All this falls under IP. IP becomes important when it is about paid online reference services such as Google AdWords. IP is also an issue when it is about restrictions of information flow, either internally within a company or a cooperation between companies, but also externally, when it is about information crossing a border. Just to give you an example, there are some restricted information that cannot easily be circulated, such as manuals for building nuclear bombs. IP becomes an issue when we talk about data protection and also when it comes to product liability issues. Another example are environmental law issues. Finally, to conclude my list of examples for IP in a broader sense, there are enforcement issues, such as border seizures. All this is also encompassed in the term IP. How does this look like in practice and what can we do about it? Please check out the courses section on my webpage, www.iplawyertools.com. Please note, there's a small subscription there and there are course fees, and they come all with a 1 month, 100% no question asked money back guarantee. So the risk is on me. My name is Martin Schweiger and I have just walked you through lesson 2 of our IP Bootcamp. Goodbye.